afternoon, Chairperson and members and stakeholders. I did not receive any apology, Chairperson.
Okay, let's get going. What I suggest is, please note that you have received about 14 documents. There's a 12, I can't recall, from our secretary, and later a list of all the documents, most of which you'd received before. We also have, in addition, it's 15, Dennis. Okay, great. What's the difference for about 14? Now, you've got the whole of Saturday, and, well, unless we have a meeting on Sunday morning, the whole of Sunday to redo. What's the big deal? Okay, so basically, we also, I approached Frank Jenkins, the advocate, Frank Jenkins from our Treasury. I'm saying Treasury, Legal Services Unit. I'm looking at Treasury on the screen here with the PowerPoint. And I said to him, look, it's a bit unfair to dump it at you at this late hour. He was caught up in another meeting, but hey, presto, he's delivered a response to Jeremy Gauntlet's legal opinion. You also have a letter from the minister which was sent to me. I should have forwarded it to you before, but obviously I thought I'll do it around the time of the bill, and I've had another read of it. As you have now, 5-page summary of the key issues from Poppy Ntaka and the team. That's from our side, the research unit. So, and there's some questions she's raised there. She told me this lunchtime that she didn't raise further questions because Treasury's addressed them, and that's fine. But obviously, we need to also have our own opinions, and she will come back to us, as will the team, before Tuesday on what they think of the responses. Now, that's their independent view, remember, they're not obliged to do anything to fit into the political parties' positions. They give us the independent view, and then we evaluate it for what it's worth, meaning from our respective party political points of view. And hopefully there's enough in common from what they say that binds us at least on those issues that the research staff assists us with. Right. Having said that, the process will be that Treasury will reply. Originally, they've given us a PowerPoint presentation. Then the stakeholders, in the order that they appeared, or they can juggle it around. COSATU is distinct, but the others seem to be overlapping quite a lot. They can speak as they want, and then we will engage around the broader policy issues. And no, what we will do is have, is this agreeable? First, let's get Treasury reply. Then let's get Frank to present his independent view on Jeremy Gauntlet's opinion. And then let's throw it open to the civil society stakeholders, and then we will engage. And we will sit till 5. If need be, we'll sit longer. And then we will decide where we go from here, depending on how things pan out, by 5 o'clock. Okay, over then to Treasury. Who's leading it? Vukile, is it you? We've all got.
I am, Chair.
Yeah, please go right ahead. About 45 minutes, will that do you and your team?
I think so, Chair. I think so.
Good. Let's go for it. Yeah, but you know what? It doesn't matter if you take an hour. It's fine. Yeah, but no more than an hour, because I can't see why you should take more than an hour unless the majority in the committee agree, in which case you can have as long as they decide. Right? Shall we go for it?
Yes, Chair. Janine's wondering
if you help me. And no wisecracks from you, Dennis. I've been very good as a chair today in Kululeko, don't you think? No silly-billy comments from me, right? Okay, so behave, Dennis. Over to you, Vukile. I'm sorry about that.
Thank you, Chair, and thank you for the opportunity to respond in more detail to the comments. You would have recalled last time we provided an initial response. You will see a significant amount of overlap between some of those initial responses and the more detailed responses we'll be providing today. And that, Chair, is largely driven by the fact that most of the comments that we'll be responding to today had originally been presented in the standing committee earlier, and we had provided exhaustive comments, including bilaterally with those commentators, and had, in most instances,
Akil, I'm
provided.
sorry to intrude like this. I just want to check, it's a process matter, a practical matter. In Kululeko, how many of the stakeholders are here who made submissions on Wednesday?
All four chairperson that
Oh,
were
good.
presenting,
All right.
they are here.
Okay. I don't recognize them particularly for some reason on the screen, but fine. Okay, sorry, go ahead, Akil.
No problem, Chair. Thank you. So, Chair, let me start with some broad context. Janine is helping me with the slides. If we could just go to slide 2 and on presentation mode. Thank you. Thanks, Jenny. So, Chair, as you would have noted, we had received contributions from 9 commentators by the deadline that you had set. The majority of commentators are from the NGO sector, or at least their comments relate to the amendments to that act. Chair, you would note that there were. Chair, you would note that some comments, a few comments really relate to some of the procedural elements, but I think that you have dealt with quite a lot of, you had provided quite a lot of context and explanation around the timing, the constraints around the bill. Chair, the majority of commentators do support the objectives of the bill. There are a few who are, like I say, Chair, we'd had engaged with at the level of the standing committee and gone a significant way of addressing some of their concerns. And I think you would have heard some of that in the initial presentations last week. Of course, Chair, I think there are some remaining issues, and I think that there are further I guess comments and a desire to try and get all of their issues addressed. But we do believe that we have gone a significant way to addressing the primary concerns that had been raised at the standing committee. And like I said, Chair, last week the presentations aligned with that. Chair, many of the comments received, like I said, raised similar concerns to those in the standing committee. You would recall at the standing committee, the comments process was staggered over multiple weeks. There was initial date set and then an extension. So in our presentation to you, we will be presenting the comments as we had received them. So the initial block and then the additional consultation that we had received and provide all those tables of comments. Next slide, please. So Janine, Chair, I'll hand over to Janine, I beg your pardon, who will take us through the comments in some detail. Like I say, Chair, I hope you bear with us. There will be some significant overlap, given that in our initial responses, some of the core issues had already been dealt with. But over to you, Janine.
Thank you very much. And thank you, Honourable Chair and Honourable Members. And good afternoon to all the stakeholders as well who are joining and colleagues. So the comments that were received raised a number of important aspects. They particularly focused on the amendments to the Nonprofit Organizations Act that are contained in the bill. But first, to touch on a couple of more general comments that were raised. The first related to training of prosecutors, police, and other role players. And it was highlighted that a crucial step is the training of prosecutors and police to be able to utilize the legislation in order to equip the police with skills to investigate, and prosecutors to also develop charge sheets and properly conduct and guide investigations. And it was highlighted that Treasury should work with other key organs of state, including the Auditor General, SARS, the NPA, the FIC, and the SAPS to ensure that the relevant officials are trained and capacitated to enforce the bill's full implementation. And we certainly note these comments, and those are important aspects that are raised. And it is noted that guidance and awareness raising initiatives will endeavor to be provided timeously to address these aspects that have been raised. Another important aspect was about access to beneficial ownership information. And the bill does not explicitly make beneficial ownership registers publicly available. And it was noted that trade unions, shop stewards, workers, civil society, and journalists have an important role in uncovering commercial crimes and corruption. And so, access to this sort of information is important in capacitating them to play this role in uncovering crimes and corruption. And making beneficial ownership publicly available enables these groups and the public in general to assist in fighting tax evasion, corruption, and other crimes that are needed to be addressed. So it's argued that public access to beneficial ownership information will help to effectively implement a beneficial ownership regime overall. So these comments are certainly noted, and access to the various registers will be dealt with through regulations after consultation with all stakeholders, including the regulators, and considering all parties that are impacted by the regulations and the nature of all of the information that is going to be contained in the registers. And it will likely be a stage process in line with the approach that's being adopted by most FATF compliant jurisdictions. So it's envisaged that the regulations will set out details about the access to the information contained in the register in quite a detailed and nuanced manner. And the bill also provides for the regulations under the different laws to be made after consultation with the Minister of Finance and the FIC, and this will promote a coherent and consistent development of regulations relating to the registers, and ensure that the registers and the information contained in them and the access to the information is well coordinated and consistent. So it's envisaged that the registers will definitely be accessible to competent authorities and obliged entities that have obligations on a tiered access basis, taking into consideration particularly the Protection of Personal Information Act and the Promotion of Access to Information Act, as well as aspects of international law that may be relevant. And it's noted that the overall degree of access to information by the general public is left by FATF for countries to decide. And in South Africa's case, it is important that this be really dealt with in a very thorough and coherent manner and a well-considered manner after consultation with all stakeholders and considering all of the relevant issues and concerns and the nature of all of the information involved. The revised FATF interpretation note recommendation 2, it is not mandated or required that the registry must be made generally public, but there must be some form of access, particularly to obligated persons, and to enable the sharing of information between the designated authorities and institutions, to also enable the cross-checking of data and consistency. So it's further important to note that having a registry by itself is not a panacea, and it does not ensure access to accurate information in a timely manner. It is an important base or a foundation for a system of access to beneficial ownership information, but it cannot be the only source to be relied upon by authorities, and it's also important, you know, if it's going to be ensured that there's accurate and updated information that will be available, to competent authorities and companies that are required to gather information, banks and law enforcement and other competent authorities, that the provision of the information that is needed is required, and there are obligations under the legislation to provide the information. So if this information is being provided and gathered, then it is submitted that it's appropriate to be having a register to contain the information and enable it to be accessed appropriately particularly by the relevant authorities and those who have obligations, and also you know, potentially to other persons, along as there are appropriate safeguards and all relevant interests and legal obligations are taken into consideration in determining what is an appropriate range of access to the information. And then there was one comment that was highlighted in relation to the amendments to the Trust Property Control Act in Clause 7 of the bill. And it was highlighted that trustees may need to rely on information that is provided to them. So there should be provision that a trustee will not be guilty of an offense in terms of Section 11A, subsection 1, if the trustee can show that they took all reasonable steps to establish the beneficial owners of the trust. And the new offenses or failure to comply with sections 10, subsection 2, 11, subsection 1, paragraph DA, or 11A, subsection 1, are likely to disincentivize persons to act as trustees. We have been engaging particularly with the Department of Justice and Constitutional Development in relation to the amendments to the Trust Property Control Act that are contained in the bill, and they are developing a forthcoming regulation of trust bill that will propose a thorough overhaul of the regulatory framework for trust, and that is already under development, is well underway. And so we've been advised by the Department of Justice that the future bill will propose to provide that a trustee that willfully fails to establish and keep a register of the beneficial owners, or that knowingly keeps false information of a beneficial owner, is guilty of an offense. And it will also provide for sanctions for the provision of wrong information to a trustee. So those who are required to provide information will also have obligations and imposed. And they highlight the importance that effective but proportionate sanctions must be imposed in relation to a trustee's failure to establish and keep a proper register of beneficial ownership in order for the legislation to be effective. So, you know, this is, you know, the approach that is proposed in this bill. We've endeavored to be consistent with what will be proposed also in terms of that future legislation. And ultimately, you know, the policy approach needs to be guided by the Department of Justice. And then the substantial proportion of comments that were received related to the amendments to the Nonprofit Organization Act. And firstly, important aspects were raised in relation to the alignment of the Nonprofit Organization Amendment Bill with the General Laws Amendment Bill. And it was highlighted that the bill is not aligned with some of the aspects in the NPO Amendment Bill, particularly relating to registration. And there is, some concerns raised about having these two separate processes, and it was not clear quite how the processes are aligned and how the further processing of the NPO Amendment Bill might proceed. So we did indicate this a bit in the last meeting, but the NPO amendment bill is currently still at a draft stage, and it has not yet been tabled in Parliament. And so the General Laws Amendment Bill was developed subsequent to the NPO amendment bill process being commenced, and it was already quite well underway when it was identified, that in terms of the FATF report, that there were specific concerns that we need to address in relation to the NPOs and the Nonprofit Organization Act. So, it's noted that, there are these two separate processes that have ended up underway, but we certainly would indicate that the further development of the NPO amendment bill will be informed and be based on the Nonprofit Organization Act, as it will potentially be amended in this legislative process. And so, ultimately, that bill would be appropriately revised. And also, I think, some of the other submissions that have been made in this process will be taken into consideration, certainly in the further development and processing of that bill. So hopefully then, the further processing will then be aligned with what Parliament has enacted, will ultimately may enact in relation to the NPO Act in this legislation. Then there was quite a few comments on compulsory registration, and it was highlighted that the bill should exclude nonprofit organizations that are already registered as public benefit organizations with SARS from being deemed at-risk NPOs that need to register with the Department of Social Development. And the identified limited subset of NPOs is still too broad, including a wide array of NPOs and practically all religious organizations that make donations or provide services outside of South Africa's borders, which quite likely could be a very large number, would be required to register and comply with the NPO Act or face administrative sanctions. So it's noted that public benefit organizations are currently monitored for submission of the tax returns and for compliance with Section 30 provisions of the Income Tax Act. And this monitoring is conducted annually when public benefit organizations file tax returns. And SARS does not monitor specifically funds that are expended on activities conducted outside of South Africa, except in instances of Section 18A approved entities where funds may not be expended outside of South Africa. And it's also important to recognize that the Income Tax Act and the Nonprofit Organizations Act are aimed at two different objectives. And the registration under one piece of legislation, the Income Tax Act, does not absolve and should not absolve the organization from registering under another piece of legislation and complying with the requirements under that other legislation. And it is important to note that nonprofit organizations that will be required to register on the Nonprofit Organization Act will be subject to the requirements of the NPO Act, and it is submitted that it is important that they would be subject to those requirements, particularly as they relate to the governance of nonprofit organizations. And if it was decided to allow for a deviation, specifically for nonprofit organizations in the religious sector, it would mean that other entities identified in the at-risk category will not have to register with the Department of Social Development if they are registered with SARS. And from a practical point of view, the objective of having a register in relation to nonprofit organizations is to have a unified register for the categories of nonprofit organizations that are identified as being at potential risk and that have to comply with the NPO Act. So having a fragmented approach and it is submitted would be undesirable. And we'll go into this a little bit further and other related aspects a bit later in the presentation. Then another important aspect that was raised was about the the inappropriateness for the Department of Social Development to accommodate the nonprofit directorate. And it was highlighted that there's broad support in the sector to have an oversight body which is independent of the Department of Social Development and which has funding, staffing, and systems that are particularly designed to effectively serve the sector and play a responsive and supportive role. And it was recommended to consider adding definitions to the FIC Act of a cross-border nonprofit entity or at-risk nonprofit entity or external flow nonprofit entity as the current unsuitability of the NPO directorate for gathering, secure storage, and separating out of data required. It was submitted that it would be preferable for that the registration of these entities takes place under the FIC Act as a reporting institution. And there are serious reservations as to how the directorate will be able to effectively implement and manage the additional responsibilities that they will be potentially given under the legislation. And it was also noted that excluding NPOs that are registered as public benefit organizations with SARS from being deemed as at risk, NPOs that need to register with the Department of Social Development would lessen the burden on the state and NPOs without falling foul of FATF's recommendations. And it will also simultaneously prevent numerous religious organizations from being subjected to additional administrative and/or financial burdens, which such organizations may find difficult to cope and comply with. So in response to these submissions, and there's certainly very serious submissions and we've taken them very carefully into consideration, we would note that the requirements for NPOs under the NPO Act and for which they are supervised under the Act are to have a constitution that addresses the matters that are specified in Section 12, subsection 2, to keep accounting records, to draw up financial statements and balance sheets, and to have audits of their financial statements. And so there are certain specified requirements that particularly relate to good financial and administrative governance. And the monitoring and supervision of NPOs must be to oversee compliance with these obligations. And currently, under the legislation, there is no other entity or agency that has the legal mandate to do this. Currently, it is the directorate under the NPO Act that has this mandate. And SARS, the FIC, the CIPC, and the Master's Office do not currently have the responsibility in their core functions for supervising NPOs for compliance with the NPO Act, and no other entity has any capacity to supervise NPOs for compliance with the NPO Act. And it's highly undesirable from a policy perspective to have a system where one category of NPOs who register voluntarily to be supervised by one entity and another category who are required to register be supervised for compliance with the same requirements by another entity. That would be undesirable. There should be a consistent approach to regulation and supervision of NPOs. And the discussion on capacitating the Department of Social Development to be an effective supervisor of compliance with the NPO Act is key to demonstrating effectiveness under the immediate outcome 10 of FATF. And the amendments to the NPO Act are necessary to address some of the technical compliance deficiencies in respect of Recommendation 8, but they are also lay the basis for us to address the immediate outcome 10 finding that the authorities have not applied specific measures nor commenced monitoring or supervision of organizations at risk of terrorist financing abuse. And the recommended action that South Africa should implement an action plan with clear departmental responsibilities and deliverables. They should designate a competent authority responsible for the supervision or monitoring of NPOs, ensuring that they are designated, that the designated competent authority is fully integrated within the country's anti-money laundering and combating financing of terrorism regime as being a member of the security cluster. So, it's important, that we address these particular aspects of the outcomes and recommendations that have been made by FATF. And currently, the mechanism to do this is through the proposed approach that in the bill. Part of the plan that's underway by the Department of Social Development is to enhance the NPO system, and this will endeavor to ensure seamless integration with SARS, the CIPC, and other regulators, and this will ease the supervision of targeted NPOs that fall within the FATF definition, and also those that are deemed to be at high risk. And we'll go a little bit further into some of these aspects also a little bit later in the presentation. Another aspect that's highlighted, which we will look at in more detail, is in relation to constitutionality of the amendments to the NPO Act. And it was noted that the proposed amendments will impose legal obligations and limit the constitutional rights of infected NPOs, their governors, and office bearers. The legislation, as it stands, does not pass the requirement of Factor E of Section 36(1), in that it does not employ the least restrictive means to achieve its purpose. And the commentators indicated that they are convinced that if the legislation is not amended, it will not establish a rational relationship between the limitations imposed by it and the purpose for which it is proposed. And it will not comply with the requirements of Section 36(1) and will be unconstitutional. So we will shortly go through in some detail the constitutional opinion that was obtained from senior counsel and provide a bit of explanation of that opinion and the analysis that was conducted by senior counsel. Then there was a proposal to replace the definition of office bearer, and it was highlighted that if NPO registration will be compulsory for any class of nonprofit organizations, it's important to fix the misalignment in the current NPO Act, and directors of nonprofit companies and trustees of trusts are those responsible for governance, who sit on the governing board and who have ultimate fiduciary responsibility for the organization. In voluntary associations, those who govern and have ultimate fiduciary responsibility are those who are elected by the members to serve on the committee governing body. And if the recommended amendment is not made, it is submitted that voluntary associations would not have to disclose details of their board, but those of their CEO and managerial staff. So it is submitted that it would be appropriate to give consideration of amending this definition, not in this process, but considering it further and considering it in much greater detail and giving appropriate analysis to the proposal through the separate nonprofit organization amendment bill structure process. The governing structures in the voluntary associations is referred to as office bearers, and that is those who have governing powers. And in addition, the other staff members, management, are those who are referred to as executives. And part of the plan underway by the Department of Social Development, again, is to enhance the NPO system. But we would certainly note this important comment for further consideration and analysis and engagement to determine if in the NPO Amendment Act process it may be appropriate to provide for some refinements to that definition. Then there was a comment in relation to the two offenses, clause 17, and it is not clear who will prescribe the envisaged administrative sanction and how it will be prescribed. And so the use of the term prescribed denotes that regulations would be made by the Minister of Social Development in respect of the administrative sanctions. And also consideration will be given to potentially addressing administrative sanctions and providing more detail further in the NPO amendment bill process. Then there was proposals to amend the FIC Act to provide for NPOs to be regarded as reporting institutions, and a number of proposals to amend sections of the FIC Act to provide for voluntary associations or NPOs providing funds outside the country to be registered with the FIC. We have gone into this a little bit already, and also we'll address some of these comments a bit further later on in the presentation. Then, in relation to definitions, the definition of beneficial owner, clause 18, it's noted that there appears to be the intention to provide best practice through guidance, and it is submitted that it is important for the legislature to clarify what is meant by effective control to provide certainty or some guidance. And consideration will certainly be given to providing guidance that will promote and ensure consistent application of the term beneficial owner in the different acts. And it is noted, internationally, providing additional guidance it is certainly an approach that has been adopted in some other jurisdictions, given sort of the necessity and some of the complexities that relate to defining beneficial ownership and appropriately implementing definitions of beneficial ownership in different legislative contexts. Then there were comments relating to clauses 40 to 45, dealing with administrative sanctions for non-compliance. And these clauses refer to the FIC Act, which in section 45C, a fine is capped at 10 million rand for natural persons and 50 million rand for legal entities. However, having set fines without consideration for a natural person's net worth or the company's turnover may result in little or no impact if the person is particularly rich or the company particularly large. And this needs to be revised to take into account net worth or turnover. Over and above the financial penalties, it's submitted that there are other administrative sanctions, such as that may be implemented and imposed, such as restricting the business activities of a person or suspension of registration or activities. So also penalties are assessed per offense. And so if there are a number of contraventions, then the overall amount of the penalties would be commensurate with the number of contraventions. And the penalties would be assessed based on the circumstances of each non-compliant natural person or entity, and various factors that would be taken into account include, the effectiveness of the fine. Would it be, trying to determine amount that would be an effective sanction, and in order to decide the quantum of the fine, and this would potentially include aspects such as has been highlighted as net worth and turnover. Then there were a few comments finally relating to the amendments to the Companies Act, and it was noted that foreign nonprofit companies and foreign trusts are already required to register in South Africa under Section 23 of the Companies Act and Section 8 of the Trust Property Control Act. And this proposed amendment requires the registration with CIPC and also of the foreign equivalents of voluntary associations, unincorporated or unregistered bodies and organizations which may be carrying out nonprofit activities in South Africa. And this proposed amendment either replaces the AML-CFT bill proposal to make registration as an NPO compulsory for these entities, or is needed to support compulsory registration under the FICA or the NPO Act, as one then has local registration number regardless of legal type of entity. So it was a proposed, to define certain entities as foreign companies under the Companies Act. And the CIPC and DTIC colleagues indicated that they did not support this proposal, as this would involve taking over the mandate of another authority. And the CIPC maintains that it will continue to cater for external nonprofit companies in as far as they meet the criteria set out in Section 23 of the Companies Act. And the CIPC is of the view that this is not a matter which should appropriately be addressed in the current bill, and so it is not supported to consider this proposal in this legislative process. There is still the further Companies Amendment Bill process, where further consideration can be given to various matters, but this proposal, it is not recommended that it should be proceeded in this process. Then, in relation to the proposed definition of beneficial owner that would be inserted in the Companies Act, it was submitted that it is not clear whether the legislator intends for the concept of control as set out in sections 2 and 3 to apply to this definition as well. And if that's the legislator's intention, the concept of control as used in the definition should be expressly linked to sections 2 and 3 of the Act. So the term control would take on the ordinary dictionary meaning and be interpreted in a manner consistent with FATF guidance and international law. However, if additional domestic guidance, it could certainly be considered to assist in the consistent application of the term in the different acts, and in particular in the context of the Companies Act. And then there were comments in relation to beneficial interests in securities and beneficial ownership of a company. And it was noted that the bill requires the annual disclosure of beneficial ownership through the filing of annual returns under Section 33, but subsection 12 of Section 56 would require the filing of additional notices within a prescribed period, and there is no provision for disclosure of this information or for access to that information. And the provisions sufficiently provide for setting a prescribed period within which the company must file any changes in beneficial ownership, and a disclosure, etc., and access would be dealt with under regulations that will be made in relation to the registers of the information under the Companies Act. So next, we would propose to go through, to provide a bit of a summary of the Senior Counsel legal opinion on the constitutionality of the bill, and highlight some of the matters that were addressed in the table in the current version of the bill, in light of the opinion from Senior Counsel. And so the legal opinion, which has been circulated, was obtained in light of all of the submissions that were made to the Standing Committee on Finance regarding the constitutionality of the registration provisions in the bill. And the opinion particularly examined the constitutional rights to freedom of association, freedom of religion, and the rights of cultural and religious organizations that were particularly highlighted in the submissions that were made to the committee. And in relation to the rights to freedom of association, the opinion notes that the right to freedom of association is not per se precluded from being regulated and being potentially limited to some extent. And however, in general, a provision purporting to regulate the right, which amounts to prohibiting the exercise of the right, would generally be identified as restricting the right and likely would require justification. And any regulation which increases the cost of exercising the right could be considered to have a deterrent effect that needs to be considered. So the opinion particularly conducted significant analysis of whether a potential limitation of the right of freedom of association could be justifiable under Section 36 of the Constitution. And taking into consideration the importance of the purpose of the potential limitation, it was noted that the purpose of the potential limitation would be to give effect to anti-money laundering and counter-terrorist financing standards that are recognized internationally. And it was noted that South Africa is afflicted by the growth of money laundering nationally and internationally, and the deleterious effect of money laundering on rights of people under the Bill of Rights, and the danger that money laundering presents to public order and safety and economic stability, and its potential to inflict social damage. And it was highlighted that it should be recognized that South African common law and statutory law have failed to effectively deal with money laundering, and also failed to keep pace with international measures aimed at dealing effectively with money laundering. So, you know, the purpose and its importance were noted in the opinion, and it was concluded that you know, the importance of the purpose of the provisions and the legislation is certainly undeniable. And then the opinion indicated that the nature of the potential limitation imposed by the tabled bill is registration requirements in relation to NPOs. And registration should be juxtaposed with other types of typical forms of limiting freedoms, which may include outright prohibition, barriers to or qualification on membership, restrictions on internal or external decisions an association may make, or prescriptive decision-making methods, imposing funding requirements or restrictions, or penalizing membership per se. So considering a registration limitation, which is really you know, the extent of the limitation that is proposed under the legislation, you know, there aren't proposed restrictions on you know, there isn't proposed prohibition or qualifications on memberships or decision making, or you know, other types of controls that would be imposed on nonprofit organizations. It is noted that registration is accepted under German law, and you know, the rights to freedom of association under the German Constitution are quite similar to freedom of association under the South African Constitution. And so some registration requirements can be considered as normal and perhaps even necessary to integrate the right to freedom of association within the overall legal system. And the extent of the registration limitation in the tabled bill, the opinion notes that the extent of the potential limitation would be first, and this was you know, what was provided in the tabled version of the bill. Prior to registration, the association could not commence operations. And secondly, a violation of the registration requirement is sanctioned by a fine or imprisonment, and imposing such sanctions axiomatically exacerbates the impact of the legislation if it is brought to bear. But the extent of the operation of the potential limitation nonetheless remains confined. And this is, on the one hand, because the limitations only apply to NPOs as defined in the Act. And so accordingly, an NPO, which would not fall within the definition in the Act, would not be affected by the bill. And on the other hand, even to the extent that the registration requirement would apply, it is not unduly onerous, demonstrating that registration should be received relatively automatically on application, subject to compliance with the objective requirements in the legislation. And it's notable in relation to the opinion that in the revised bill that is now before this committee, it is no longer required that an NPO may not commence operations before registration. It just provides that the categories of NPOs must register under the Act, the limited categories of NPOs, and also the scope of NPOs required to register has been substantially reduced, and also the sanction for registration would now be an administrative sanction and not a criminal offense. And so it's submitted that these changes to the bill also would reduce the extent of a potential limitation of the right. And then the opinion further noted, as in the Constitutional Court's case in Gervas, the potential chilling effect on the exercise of the right should not be overstated, and the potential limitation in question does not negate the right, but only subjects its exercise to condition. And it was noted that in the Gervas case, it's analogous to this situation in its approach to Section 36(1) of the Constitution. And the Constitutional Court dealt with the factors in Section 36(1) jointly. And it was noted in the Gervas case that the purpose of the limitation was to protect the rights of individuals whose property is damaged during demonstrations deteriorating into riots. In the current instance, the purpose of the potential limitation is to give effect to national and international commitments to protect individuals and democracy itself against terrorist attacks and money laundering intended to finance terrorism. And the opinion noted that first principle dictated that the purpose of the potential limitation cannot reasonably be served by less restrictive means constituting the current status quo, with continuing registration of NPOs on an entirely voluntary basis. It is probably precisely the type of NPO whose registration is required for the purposes of serving anti-terrorism measures that would almost invariably not register voluntarily. And the only alternative to voluntary registration is mandatory registration, the scope of which may potentially be determined appropriate. So the opinion notes that that registration is at least reasonably required, if not an absolute precondition, for the necessary risk assessment that needs to be done in order to assess the risks and potential anti-terrorism measures that where anti-terrorism risks might arise. And this is because registration is the means through which government is informed of the nature of nonprofit organizations. The nature of a nonprofit organization, in turn, enables an appreciation of the vulnerabilities to which an NPO is exposed from a terrorism financing perspective. And it is garnering information concerning such exposure, vulnerability, and risks that government is
Janine.
Yes.
Janine, can I just come in here? You're close to an hour and you are at slide 14. out of what I have here is 30. So you're halfway through. So presumably you're going to take another hour. Now, I want some advice from MPs. You see, colleagues, I just want to know, to what extent are we required to go through the complete nitty-gritty of every... I mean, we get the thrust of what you're saying. We have the document of Jeremy Gauntlett. Okay, he's a very high-powered senior counsel, but he's not God. We also have an opinion from Legal Services Unit. And, you know, I have a feeling that given the complexities of the technicalities you're going into, we might want to set up a subcommittee between the lawyers and representatives of civil society, Treasury, and our Legal Services Unit to deal with these issues, and then come and report back to us on where they agree and where they don't agree. And then the committee decides how we go forward. But I'm not sure whether you know how much you want to go into detail. But if members are wanting you to go through it at this rate, I'm cool. That means we'll have to spend till 6 o'clock at least. But fine. So what do members feel? Can I get some opinion on? I've suggested a way forward that you summarize the key points. You're going into far too much detail in my view, but maybe the others want it. So can you get some advice from members, please? Whose hands are up? Dennis?
Yeah, Chairperson, it almost feels as if the case is being presented to us as if we are the Constitutional Court.
Yeah, funny. That's an analogy I was thinking of, like you're speaking to a court. That's exactly what is going through my mind, Dennis. I didn't want to say it because Janine is a bit soft and might, you know, feel criticized. But if it was Momo here, I would have told him off, right? Because he's got a tougher skin. So I'm glad it's you. Janine, we love you, but you know what? We're really not a court. And our issue is the policies. And finally, you know what? Whether it's Jeremy Gauntlett or whoever, or Frank Jenkins, or you as a lawyer, or these civil society stakeholders, lawyers, you know what? The courts will decide. So unless somebody feels very strongly, Dikeledi, yes?
Thank you, Chair. I want to agree with your suggestion. I support your suggestion that it will at least help us, because the way it goes, the level of concentration, we might lose the level of concentration, and because it's complicated as well. Thank you.
You see, maybe you also need to know, Janine, we were stuck this morning with the Appropriations Committee and Wukile and them, right? I got kicked out at 12 o'clock when we got a load shedding thing and my 4G wouldn't connect. So I don't know what time they finished, but shortly after 12 or 2 minutes after 12, they were still at it. So it's a long day, but we will do what we have to do. As I said, Sunday is available, and I've got Saturday afternoon as well. Now it's opened up for me, so I'm cool. But I think we're agreeing that this matter should be covered in key points. Actually, you know what? I think we got the drift of where you're going. And I browsed through Jeremy Gauntlet's stuff this morning. I'll have time over the weekend to read it. I'm not sure that I'm going to read it like I'm going to look at the submissions by civil society stakeholders line by line, but I'm not sure I'll do it. It's really not our job. You people must just come with bills from the executive, and Parliament mustn't approve of bills unless they're constitutionally sound. And we're not able to judge it anyway, Ginny. None of us is a lawyer. Yeah? Actually, I'm the closest to being a lawyer, Ginny. I've dealt with so many constitutional issues since chairing local government that I think I'm probably the closest. I don't know why some university doesn't give me a honorary PhD someday. I've qualified. Ask Frank Jenkins. Even before Frank turned up, I was dealing with lawyers endlessly with powers and functions, and we had Jeremy Gauntlett and Wim Tringrove and Morane and all the big wigs, Vincent Maleka, and on they went. Okay, look, deal with the key issues. Don't slide over everything. Just summarize them very quickly. And let's deal more with the policy issues. And then we'll see. We'll ask what the NGOs want to say. And if they want to continue, great, you can do it. And if Njadu or DNS wants to go, they can go. to the meeting. Any member of the committee is welcome to attend those meetings. And if Njadu goes or Dennis goes, they can even chair it. Okay, fine, let's go on. Janine? Don't get frightened. We're merely saying, can you just focus on the key issues, of the proposal from, the opinion of Jeremy Gontel. Thank you, Janine. Janine, you haven't run away now.
So just to make a final comment on the opinion, basically the opinion concluded that the provisions in the bill before the committee, in the tabled bill, they just recommended that there should be a deletion of references to where there would be potential further regulations that might be prescribed for licensing requirements. And so they recommended the removal of those references and also potential prescribed transitional arrangements. And that has been implemented through amendments that were adopted in the National Assembly. And so the opinion advised that if those amendments were affected, then the licensing requirement provisions in the bill should not be likely to be subject to successful constitutional challenge. And then they also just highlighted that the powers that were concerned, powers of the directorate that were raised as concern about powers to refuse registration or to deregister NPOs or to require changes to the constitution of NPOs, that those, even without the amendments that have been included in the bill to explicitly make the actual current situation in the Act explicit, those powers are not discretionary. They're subject to very objective limitations in the legislation, and so there should not be a potential for those powers to potentially be abused in a manner that was raised as some concern in submissions in the Standing Committee on Finance in particular. Just one final point that I'll touch on and then conclude is about the proposed change to NPO registration to reside under the Financial Intelligence Center as opposed to residing with the Directorate for Nonprofit Organizations. We touched on this a little bit already, but I'll just make a couple of other points. So it should be noted that the requirements that would be applicable to nonprofit organizations, if they were required to register as accountable institutions under Schedule 1 or a reporting institution under Schedule 3 of the FIC Act, would not be appropriate or aligned with the scheme of the FIC Act. And it wouldn't be appropriate for NPOs to be subject to some of those requirements. And NPOs that would be required to register under the FIC Act would be regulated and supervised differently from those who voluntarily register under the NPO Act, and that would be undesirable. And it is important that there should overall be consistent regulation and supervision of NPOs. And the proposals to exempt NPOs from registering if they are registered with SARS or another registry.
Yeah, I know you've covered these issues really. I mean, Jenny, yes. It's over explaining. Yeah, you can just jump on.
And it's just important overall that it isn't just about registration and gathering information. It's also that the NPOs do need to be subject to some regulation and supervision. So I think that's the rest of a lot of the rest of the presentation was more for information, just to summarize the amendments that have been made to the bill to the tabled version of the bill that were adopted.
Yeah, you see, I did look. So I won't go into. You know what? I think that, you see, we are not doing a clause by clause treatment now. What we're going to do is when we do the clause-by-clause treatment, we will look at those slides that are your latter slides. That I was going to get there anyway. I'm not so sure, members, because I've been through the slides actually swiftly in the hour and a half or so before this meeting. And I must say that Janine's right. For those of you who haven't had a chance, you'll have the next 3 or 4 days. You've got up till Tuesday to go through them. They're very clear, Janine, very clear, I must say. So it's not as if any members need explanations of them. We will seek that on Tuesday. Let me go on to suggest that it's time now to look at what Frank said. And because our staff is so shy, I will take you through what Poppy and them have said. Okay. Now over to you, Frank, and we've distributed your submission. Or your
thank you, Chair.
Yeah, thank you. Members, you've got that, and we can put it on the screen via Nkululeko as well. Thank you.
Okay, thank you, Chairperson. I can put it on. No, let Nkululeko put it on. I've done a screen sharing. Chair, I'll continue. It's Friday. It's 3 o'clock. So if Nkululeko can put it up, it would be great. I don't have a PowerPoint presentation, but Chair, I was asked to do this note by yourself in response to the public hearings that were happening on the 23rd. I looked at the YouTube video, and my apologies for not being in the committee. I was asked to be in the Rules Committee and just to be there and advise on certain things. The two issues that came strongly out of the public hearings, in my opinion, Chairperson, the one is the issue of public participation, and the other, of course, the constitutionality of certain clauses that affects the NPO sector. I am going to just deal first with the issue of, and as we speak, Nkululeko can raise the opinion that I've presented, or I can speak to it as it is there. But
yeah, there it's on the screen. Yeah. So Nkululeko, you can go to the part on public involvement at the bottom of that page. What I did there for the committee, and what I'm doing, let me put it to you, this Chair. It's been said, and I was going to start with it before it was being said. I'm not here to argue a matter before you. I'm here much in the capacity as a person who's trying to assist the committee. Difference between myself and other people, of course, I get paid to do it. So I'm trying to assist the committee, and I'm not trying to sell any argument to the committee. On the issue, then, on the two issues I'm going to deal with in this paper, the first is public participation. Now, I've put on there in paragraph 4, and I'll read the paragraphs and Nkululeko can keep up. Put on paragraph 4 that whether a bill is 75 or 76, the Constitution requires that there's a facilitation of public involvement. And it's just depending on the bill, depending on the specific mandate of the House or the committee, these kind of facilitations can take different forms. The test, however, has been set out. First, in the Clicks case in paragraph 4, that there must be a reasonable opportunity that's offered to members. There must be a reasonable opportunity, Chairperson, for all interested parties to know the issues in the bill and to have adequate say. And there's two very important parts that is there. Chair, the test then, what was set in that, what was the new Clicks case, Chair, was then taken forward, and that's a seminal case at this point in time, Doctors for Life International. Paragraph 5 deals with the test, and I've got a quotation there. The critical issue is there must be a reasonable opportunity for people to participate effectively in the lawmaking process. And one can read the test further. There's two aspects. There's first the issue of trying to empower people so that they are able. This will include giving them copies of the bill, giving them copies in the language that they want, giving them sufficient time to prepare for the submission, etc., etc. And it will all depend from time to time what is necessary for the specific bill, how much interest there is, what's the impact. Maybe there's a specific impact on a defined group, in this case, the NPOs and so forth. And on that last matter, I refer in paragraph 6 to what we call the SAVA case, the South African Veterinarian Association. It's a critical that I point this out to the committee. In the SAVA case, there was a bill that created certain obligations for the medicines and related substances and for the medical practitioners
But at the last moment, without public participation, a clause was included there that deals with certain medicines that the veterinarians are using. So, Chair, that last bit, the veterinarians didn't know about. The veterinarians didn't have an opportunity to make submissions. And because of that, the whole bill was found to be unconstitutional. I discussed it a bit in paragraph 7 and paragraph 8, and then we get to Matatiel, which is also quite a seminal case about the change of provincial boundaries. And again there, the court highlighted that if there's a group that has a specific interest, one must take that specific interest at heart. So it depends from case to case, Chair. But again, in the Matatiel matter, there were promises that there will be public hearings, and those were not held. So I want to, and I say this with respect to Cause for Justice, but they did it in their submission, and sorry, their FJ makes submissions, that must be CFJ, that's at the bottom of 10, that must be CFJ. Cause for Justice in their submission points out these 4 instances where they were allowed to make submissions to the Standing Committee on Finance, Chair. And of course, now we add in paragraph 11, the public hearings on the 23rd of November. And in my opinion, Chairperson, this is what one can look at if you want to apply the test. I don't want to make a comprehensive analysis here of the specific test and how we should treat this bill, etc., etc. I also do not want to make a judgment whether a court will find the public participation on this bill, both in the NA and the NCOP side, reasonable, but that is the test. But what is clear from the facts, and I'm saying this, so I want the committee to have a relaxed weekend if it's possible. And that is clear from what the stakeholders have said and how I've been following this bill from the Standing Committee to the Select Committee, that there has been a vibrant discussion during the public hearings on the original version of the bill. That discussion resulted in the B version, which is now before the committee. So what is in the B version is not new. It's not the department that came with versions that had nothing to do with what happened in the public participation. This is what the public was being asking for, the new amendments to the B version. So although, and I'm saying that at subparagraph 2, Roman 2, although time allocated for making further submissions on this B version was short, one can't ignore that, it's a fact. The issues were not new. They've been presented, and there was a consequence of the process in the National Assembly. So that needs to be taken into consideration when when a court will consider whether there's reasonable public participation. So, Chair, I want to say that it's not actually as easy as to say, because of a short time period, it was unreasonable, and therefore your whole public participation exercise will be unreasonable and unconstitutional. I certainly don't agree with that opinion, and I do think that from the evidence of the stakeholders themselves, that there was vibrant discussion, there was meaningful participation, dialogue, discussion between National Treasury and the stakeholders to come up with a B version of the bill, which is before you today. So I want to leave that there, Chair, and I'm certainly not, and I'm saying with respect, I do not think that our public participation process here has been lacking. It could have been done better if a year had 600 days in. But at this point in time, we do what we can do. And Chair, from my view, there's been quite sufficient public participation compared to some of the other exercises I've been involved with, and compared to what I've seen that what court cases would consider unreasonable. There's nobody has been prevented from making submissions. Nobody has been shut down or said that they cannot submit something because it's a day or two late. And Chair, let me actually, and this, you are very aware of this because that is how you, in my view, chairing the meetings. If one look at what has been said in that quote that I've done in paragraph 5, at the end, Judge Nkobu quotes that the last sentence, in the sense public involvement may be seen as a continuum that ranges from providing information and building awareness to partnering and decision making. So it's not an event, it's a continuum. It deals with a dialogue between stakeholders and Parliament. And in my view, this is what has happened here. And I would leave it at that, Chair. Concerning the submissions that saying that there's a lack of constitutionality or there's an inconsistency with the Constitution, Chair, I agree 100% with Advocate Gauntlet and Pelser in their opinion. Their opinion takes a two-step approach, and I'm not going to repeat what Janina said, but it's a two-step approach. That's something that comes from, if one wants to be a Chair, you are a constitutional lawyer yourself, so by practice, but it comes from a constitutional court case in Canada, Rex versus Oakes. It's not in the opinion. This is just in my memory from the days I studied. The Rex versus Oakes started with the two-step approach. First one determines whether there is a constitutional limitation, and if so, then one goes to whether that's a justifiable constitutional limitation. The opinion basically accepts that there's a constitutional limitation through the requirement for compulsory and mandatory registration of NPOs, and then proceeds to see whether that can be justified in terms of Section 36 of the Constitution. Now, Section 36 of the Constitution, one must remember, is not a closed list of issues that can be taken up to determine whether an infringement or a limitation, not an infringement, a limitation of a fundamental right is justifiable, is reasonable and justifiable in an open and democratic society. The test remains, is it reasonable and justifiable in an open and democratic society? And it gives those 4 issues, is it 4 or 5 issues in Section 36 that one then looks at to determine or to help with this 5 issues, with this issue. And what stakeholders have focused on is the last 2 issues in Section 36, namely the balance between the limitation and its purpose and whether there are less restrictive means. The opinion itself, Chair, deals with this simultaneously. Court cases have dealt with these 2 issues simultaneously, and the stakeholders as well. So, Chair, as I understand the arguments from the NPO working group and Cause for Justice, Chair, is that this bill won't achieve its purpose. There's a good chance, let me put it that way, that the bill won't achieve its purpose, and therefore the whole proportionality, rationality argument will be against this bill when it goes to court. It won't achieve its purpose because of the failure of the NPO Directorate. I'm at paragraph 17 now, Nkululeko. Because of the failure of the NPO Directorate being situated within the DSD, the Department of Social Development, and there are issues with them, backlog issues, capacity issues. I'm just having to believe what is said. I have not tried to register that. I do not know what is really the problem there. But Chair, the short answer in paragraph 18 is that the B version actually speaks to these concerns after the National Assembly process. First, there's a deeming provision, which says that once you've applied to be registered, you will be deemed to be registered unless there are issues where your registration, you get a notice there in terms of subsection 3 of section 13 of the NPO Act. Unless you get a notice to say there are issues with your constitution, we cannot register you, you are deemed to be registered on application. That's the one area that the B version has changed from the A version, from original, the tabled version. And Chair, the other issue is that the B bill specifically allows the Directorate to delegate specific administrative functions to another organ of state to assist it. So that will take, if I could use a metaphor, it will take the wind out of the sails of the boat that says this is all unconstitutional. Because there are mitigating issues that's been built into the B version of the bill to prevent this kind of lack of connection between the purpose of the bill and whether it's when they're going to achieve that purpose. And that speaks also to the issue of least restrictive means to allow what we say monitoring of the NPOs according to the FATF standards, Chair. So, Chair, my conclusion from the time that I had to look at all these things, Chair, is I do not share the views that this is unconstitutional. I think the argument that it's unconstitutional could be scaled down to we could have provided more chance for public hearings. Whether it's necessary in the question you ask is 100% correct. Would it have changed the quality of the input? I can't answer that, but that's something. And of course, one can deal with that. But in terms of the content, whether the constitutionality can be questioned, I agree with the opinion submitted by National Treasury that the bill is unconstitutional, Chairperson. Thank you very much.
Thanks, Frank. Just to alert the civil society stakeholders, the Legal Services Unit is obliged in terms of parliamentary rules and their own professional ethics to give independent legal opinions to Parliament. So they don't kowtow to a committee. And obviously, Frank Jenkins wouldn't do that, nor would I undermine myself by asking him to do it. He's just told to give us his opinion. So you're welcome to disagree with it, but he's not a political functionary in this Parliament, nor indeed is the research unit and the content advisor. The only time we intrude on them is when we say, these are the recommendations of the committee, please put it as we want it, because that's really what we do. Their summaries of your inputs and so on are really based on what you say and or what they, if you don't submit a summary of what you've said, what they think is the key or are the key points. So, I'll just take you through a summary. Preferably they should do it really, as happens in other committees, but fine. Now we've got the document. It's the research unit's document. And they go through the first page, as you can see. Can you put it on the screen if possible, in Kulileko?
Okay, Chair, will do.
Yeah. Okay, I'll switch my video off. Maybe that makes it, I don't know if it works, but articulates. Yeah, there it is. So colleagues, basically the first parts we know why, the report of the, excuse me, FATF, the evaluation report. I think the Parliament's YouTube people want us to put our videos on when we speak. What's the purpose? We know. Then the key proposals, they're what we've been covering since the first briefing we got from Treasury, so I won't go through that. Because in fact, it's just sitting out, and remember we're going through the bill clause by clause next week, so it falls under there. Now, the first one is definition of beneficial ownership. That's been covered, right? And there's their response there. Okay, you can decide on that. And yeah, making beneficial ownership registers publicly available. I also support that. And I heard you, Janine, but we will come back to you. That's a policy issue of the committee. Now, she's got here what the recommendation has been covered by Janine. We'll give you our own independent views, whether we agree or disagree with you, Janine, and Treasury. Lack of participation, irreconcilability between the two bills. So all those issues were covered. So the questions that are put to the committee are, what is being done to capacitate the DST as an effective supervisor of compliance with the NPO Act? Now, this is a question you did address, but I really would like you, Janine and Fukile, to address this more clearly and more precisely, because you did answer, but there are a few gaps there that I'm sure members have picked up. And who's going to monitor this? This thing you've covered already, beneficial ownership. With respect to training of prosecutors, police, can National Treasury expand on what these awareness raising initiatives look like and entail? Can you respond to that as well? Okay, so that's there. Then all we've got now to do is to hear from civil society, and then we'll throw it open to the members. Okay, let's start, in the order that you spoke. And you know your order, right?
Yes,
so the NPO working group, yeah, can you go ahead? Yeah.
Thanks. I won't delay the committee unduly here. I just want to say that we have made our points, and the detail for me of Treasury's response under time constraints is mollifying. And so thank you very much for that, Janine and others. I've got one remaining practical issue, which I don't know if Janine and the others, Bugila, can take away and think about. And that is that we understand the need for a separate and central registration of the class of at-risk nonprofits. I agree that PBO registration or lack of it is not relevant or useful in the circumstances, but suggest that perhaps in the way it's implemented, and I don't know if it needs to be in the Act or it could be in regulation, that there's a separate kind of identification marker within the NPO system for those targeted nonprofits, those who are thought to be at risk. So that they map, this is just into a practical consideration in terms of trying to give effectiveness to in the long term, so that there can be a separate and specific surveillance. And I mention this because quite a few of the practical issue will be that a lot of the organizations which fall within that definition might already be registered as nonprofit organizations. So they're not going to arrive now at this stage and say, okay, yes, you've got us, here we are, we'll register because of this thing. They're already in the system, and it's a huge system. There are a lot of organizations registered. So there might be a need to add a kind of a notification update marker requirement for those organizations already inside the NPO system, which maybe need to say, okay, we're there. Because there's nothing, insofar as I can tell, in the way that the NPO department, they currently monitor the reports, which would alert them to the things that are needing to be picked up on in terms of cross-border transactions. And my colleague Anne, have you got anything? I know there are a couple of other colleagues in the room. Before I hand over.
No, I'm very pleased with the thorough way everything's been handled. And yeah, my big concern is the capacity of the DSD. Yeah, that's my biggest concern. But thank you, everybody, for all the hard work and for all the opinions. Thank you.
Yeah, and look, if the outcome from this process is that there is a whole lot of time, effort, and money spent on making the DSD systems actually work, or the NPO directorate systems actually work, that's a major bonus for the sector in terms of supporting it and making that NPO registration something that's credible again. I think we'll take the fight about having an independent NPO directorate into the next arena around the NPO bill, and that will be an ongoing discussion. But thank you very much, colleagues.
Okay, who's next? Is it Helen Suzman Foundation? Are they here in Kululeko?
Yes, Chairperson Chelsea is here. Oh, yeah, yes, Anton.
Okay, Anton.
Thank you. Sorry, I'm going to let Anne van Dalsen speak first from the Helen Suzman Foundation.
Okay.
There's just one point I would like to make, Chair, and it won't take me long. This regards the registration requirements which are to be put in place. And the concern is, will the mechanism that is decided on to regulate in NPOs actually be able to do what it is supposed to? And this question is very relevant, especially in the light of the lack of resources of the Department of Social Development and the comment in the FATF report of October last year that said South Africa has no capacity to monitor or investigate NPOs identified to be at risk of terrorist financing abuse. So we wish to support the proposal that was made of using FICO for a more effective mechanism by making the relevant NPOs to be reporting institutions in terms of FICO. Now, we've taken note of the response of the Department of Finance that it's not for them the best solution to have two different departments regulating NPOs. But I would like to make one point here, and I think it's very important, and that is that the FIC does not regulate institutions. It is there simply to step into an area which is very fraught with all kinds of things and where they have the proper resources. For instance, the banks are not regulated by the FIC, they're regulated by the Banks Act and the Reserve Bank. And I'm sure that estate agents aren't regulated by the FIC either. So to say that you cannot have the FIC looking at specific aspects of NPOs because you don't want two different regulating departments, I don't think that argument holds water at all. So my proposal would be, and this is because the DSD does not have the resources, and if it is going to take up the role of having to investigate, should we call it funny business by NPOs, then it will have to scale up very quickly in an area in which it has zero experience. And my question is whether, against this background, whether it is not better to have the FIC not as a regulating department, but purely given the powers to step in where it's necessary. Thank you. And I think my colleague Chelsea just has one or two comments as well. Thank you, Chair.
Thank you.
Hi, sorry. On a similar line, and bearing in mind from the legal services we just heard now, my concern with the deeming provision is that I don't think it will achieve the purpose for what, the changes are being made for. If NPOs are deemed to have been registered, it doesn't mean the directorate has dealt with or processed any of these applications. And for that matter, then they won't be able to monitor or investigate any of these NPOs. I just think that needs to be taken into consideration when we look and say deemed, because the NPOs may be able to continue business and it might not impact on them in that way, but it won't achieve the purpose of the necessary amendments in order for us to be compliant. Thank you. That's all I have to say.
Thank you. Who's next? Cause for Justice.
Thank you, Honourable Chairperson and members of the Select Committee. I just want to say that we thank the committee for again allowing us this opportunity to respond to Treasury's response to the oral submissions of Wednesday, and we recognise that it shows the committee's commitment to ensuring a reasonable public participation under the rather peculiar circumstances of this bill. We are definitely not ignorant to that. Perhaps in our concerns for NPOs less fortunate than ourselves, who may have been negatively impacted, we have put perhaps quite strong case, but we do take note of what parliamentary legal services have said and what they've said. But as said, we are grateful. We're not ignorant of the participation opportunities provided to us by the Standing Committee and the National Assembly and being provided by this committee. We also want to thank the committee secretary for providing the 15 documents. We thank National Treasury for again, as in the National Assembly, respectfully considering and generally in a very thorough way responding to stakeholder inputs and concerns, including ours. On Wednesday, we raised 3 remaining concerns that we had. First was the appropriateness, in other words, the constitutional defensibility of the limited subset of at-risk NPOs. Secondly, the capacity of the directorate in effectively implementing and overseeing compliance with the bill, and specifically identifying money laundering and terrorism financing, and thirdly, what the prescribed minimum sanctions would entail, or at least who will prescribe what these are. As to our first concern, we note National Treasury's response and the provided senior counsel opinion, also the opinion prepared by parliamentary legal services. We are grateful for having received these documents, and we will certainly consider same carefully. As to our second concern, we also note Treasury's response. We would emphasize the crucial importance of whichever entity oversees compliance in the end, that they must do so effectively to ensure that the whole process of the bill has not been in vain, and that the laudable objectives of the bill are in fact achieved. As to our third concern, we also note Treasury's confirmation that regulations will be made by the Minister of Social Development in respect of the administrative sanctions, and that consideration will also be given to addressing these further in the NPO bill. So thank you for clarifying that. In summary, we'd just like to say that we think great strides have been made in In respect of the bill, it is certainly greatly improved. We recognise the hard work that has been done in a very short time by National Treasury, in Parliament, and by the other stakeholders. And we are grateful to have had the opportunity to participate in the process. And it is our sincere hope and trust that the result of this legislative process will be the production of a constitutionally sound bill that can and will be effectively implemented to achieve the laudable objectives of preventing and combating money laundering and terrorism financing in and through the NPO sector, and of course to avoid parade listing, as this will not only be in the best interest and well-being of the Republic and its people, but also ultimately of the NPO sector as well. Thank you, Chairperson.
Okay, Kusatu.
No, thanks, Chair. And yeah, I think we also want to kind of appreciate the efforts and the accommodation of the committee and Treasury. As Chair, as Kusatu, we support this bill. Our stance is influenced by the real context of state capture of corruption, of the need to recapacitate the state to deal with these, and also to shine the spotlight on private sector corruption as well, which often has been left to get away with murder, so to speak. Chair, our critical focal points as Kusatu and sector affiliate was around business ownership, the definitions around access of public to information, etc. And of course, we were keen on the issues of politically exposed persons, politically influential persons, which I think have been addressed. I think, Chair, we're quite pleased with the efforts by the Standing Committee in the NA to address in the Treasury as well, to address our concerns around beneficial ownership. We're so pleased that has been addressed, and that's quite a major substantive amendment, which really thinks can be quite beneficial. We are still a little bit concerned about the issue of public access to that information. We don't think it's sufficiently clear, but we do appreciate the commitment of Treasury to address that in regulations, and we'll be keen to engage with Treasury once the bill is promulgated into law, etc. So we think that's a fair way forward. But Chair, I think members are also right, and Treasury I think is right to say you can have a very good law, but it's also the question of enforcement. So we must make sure these registries are living registries, because we have seen before with the Sexual Offenders Registry, it's there on paper, not in reality. We have seen before in the PIC Amendment Act that often government entities ignore their legal compliance requirements. So I think that will be a challenge for all of us to make sure it is effected. Chair, I think we want to, kind of in conclusion, as Kusatu, to say we support this bill's passage. The President's assenting to it, its promulgation, and everything that must be done hopefully by December by Parliament. We hope the President will assent to it in January, so we can meet the tight February deadlines. We don't think we can afford to miss those deadlines in terms of the economy and grade listing, etc. Chair, I think just lastly on the issue of public participation, look, the timeframes was not ideal. Treasury, did blunder by taking long to table the bill, but I think we have made up for it in terms of the accommodation given by SCOF, in terms of public participation, in terms of the amendments that have been revised. And I think there has been ample space for public participation in these processes, and we can point to the revisions which have accommodated many of our concerns. So we're quite comfortable in that regard. Chair, the legal opinion is correct to say you have rights in the Constitution, but you also have responsibilities. There are some limitations. We are comfortable that we found the relative balance, so to speak. I think, Chair, many of the frustrations of NGOs are legitimate frustrations, and we really think it's a chance for DST to take seriously the issues of their frustrations, the issues of capacitation for their registration requirements, and similarly with SIPs as well. But Chair, I can also say as a trade union movement, we also have to go through registration requirements as COSATU annually, our affiliates annually as well. And of course, all of us, we are irritated by them. But I can also say, Chair, if we didn't have those requirements as COSATU, as affiliates, we would be in a very scary position, because we can see the challenges of corruption, of misbehavior, endemic in society, in any organization, be it a union, NGO, be it a church, be it government, be it political parties, and we need to have these rules in place to protect the integrity of these institutions and protect the interests of the public and members at large. So we're comfortable with the bill, Chair, and we're quite pleased with this going forward, Chair. So let me stop there, Chair, and thank the committee members for giving us space, and the Treasury as well.
Thank you very much. Okay, so now where we go is obviously Treasury, you'll have to reply to the comments made by the stakeholders. But before you do, let's now hear from committee members. We all have questions both to the NGOs and yourselves, and then we'll come back to the NGOs as well. Okay, so where are we now? Who's got their hands up? Let's see. In Kulileko, Dennis. Can't somebody else speak before Dennis? Does he reserve this right to speak first? Willie, why are you scared of your party leader? Why do you never put your hand up before him? Is there some DA rule that the leader of the... I see he took his hand down. Did he do that? Or did he put it back?
You know when you're a boffin in something, and I know that my colleague is a boffin on this, so I'm not going to even try to look clever on this. I'll leave it in the capable hands of Dennis Ryder.
Okay, as long as it doesn't present himself as a boffin on law, okay? And
well, he certainly is a bigger boffin than I am.
Right, well, okay, you're a real imbongi, eh? Okay, right, fine. Okay, Dennis, who else? Okay, while other members are thinking about it, let's go in. Jadu, I take it you'll come in, my friend. Yeah.
Thank you very much, Chair. So, Chair, Billy is quite incorrect. He's actually the legal boffin, and I know a few things about the finance side, but Billy's the legal boffin, and that's going to come.
Well, actually, I am, but let's not argue. Yeah.
Well, there you go. I'm talking about between him and I, obviously, Chair. I wouldn't cast any aspersions on your knowledge.
I was forced to make up, yeah.
No, Chair, but that's kind of my point. And I want to be a little bit critical of Treasury, and please, I don't want to make anyone feel like they've done a bad job today, because they really haven't. But I do want to say that I wish Dr. Jantjies was here, because they previously had the Death by PowerPoint award for this year, and Treasury has been a late entrant, but they've taken it by far. So, well done, Treasury. You got an official award from us. But
Vakile Janine is not directing at you personally. Obviously, you go through your slides with your DG and so on. Yeah. So you should target.
Of course. As I say,
you should target Momo. You see, if it rains tomorrow and you have a birthday party, you have a great granddaughter and it rains, target Momo. Momo's the bogeyman, as it were. Okay.
Sure. Thanks. Yeah. But I do think that we got into a little bit too much depth today. And I understand it's a difficult balance to find, because if you don't give us enough, we're going to tell you you don't give us enough. But I do think that there was a little bit of, and I'll use Siraj's favorite term, there was a bit of crowding out of some of the key issues that were raised early on in the week, to focus on some of the issues there. And I just felt that some of the other concerns that we raised have not really been properly addressed. And one of those that I'd like to highlight is the issue around the proposal that was made about looking at reporting and accountable institutions and the differentiation between the two of those. And if there was comment on that today, it was lost in the volume. And I used to be very distrustful of my officials when I was in government, and they would bring a big pile of documents to me because it meant there was something hiding in there. So, but yeah, I'm not saying that's what happened today, but I don't think we got a good response on the difference on the proposal and shifting things from accountable institutions to reporting institutions. And I think Mr. Van Dalsen today made an excellent point, or made several excellent points, and I'd like to associate myself with his comments about, who does the regulation and who does the oversight, and his example of the FIC having oversight. And I realize we've got the FIC Act, but the FIC does the oversight portion of it, and I think it is quite important. And when one considers, and I do think that Treasury's made some big amendment or a big difference through the amendment that they put through, which I guess kind of underscores the point that's been made all along, is that this was a very heavy-handed, quick knee-jerk reaction. And I know that you don't like that comment, and I know that some of these things have been coming a long way, but it does seem like a throw the kitchen sink at the problem approach was the first step. So what we've got now is that there's been a big drop, but what it's dropped from there's over 250,000 registered NPOs in South Africa. And it's dropped down to now that there's going to be 10,000 that are going to be under the microscope. And I think the really important point that I started to make clumsily last week, but that Mr. Van Dalsen made clearly today, is the fact that, you know, we don't have the capacity, certainly not in the Department of Social Development, to monitor 10,000 entities, to register them properly, to get all that paperwork sorted out behind us in a reasonably short and sharp period of time, which is going to make the FATF happy. And so this process is going to be, it's almost going to set us up for failure. And I really don't want this bill to be counterproductive. So I still don't believe that we've got a product in terms of the bill that's good enough for us to support it. I think that there are still too many hurdles for us to jump through. I do believe that, and getting to the constitutional comments about the public participation process, when you've got 250,000 interested and affected parties, if you want to call it, and there is such a short space of time, it is fairly problematic, especially when one considers, and I think that the chair brought up the issue last week, is that there's no umbrella body, there's no kind of official spokesperson for NPOs in South Africa, and I do think that is currently a shortcoming. So it's perhaps not a comment on the bill, but it's a comment on the situation we find ourselves in, as far as having that spokesperson body. Chair, beyond that, I do think that we've had excellent presentations from the stakeholders, and we have had very thorough and comprehensive responses from Treasury. I think generally a job well done to date. But yeah, I remain concerned. Thank you, Chair, for your ear.
Okay, can I come in then for now? See, the first thing I thought maybe I should address is the public participation issue, because that's quite crucial. And I wanted to say firstly, that the committee regrets deeply the limited space of time allowed to civil society to participate, right? I mean, we've said that before. We have expressed our severest criticism of National Treasury. And when I say that, it's not so much to individuals here, it's the acting DG and the minister. They're ultimately answerable, and previous ministers. But the way things have panned out, unless I'm misreading the mood and not seeing in between the words of what people are saying from civil society and others, mainly them, they matter most right now. It's turned out, I think, that they seem to be reasonably, let's say, okay with the level of their engagement. But they must speak for themselves in the process, both on the NA side and here. Now, while we have been very critical of Treasury, you know, now that I've read much more, and I read carefully the minister's letter in the hour and a half before I came to this meeting at 2. I came, I mean, walking from the study. I mean, walking from my lounge here to the study, which is about 15, 20 seconds. You know, I looked at everything carefully. I went through Jeremy Gauntlet's thing. I didn't read it line by line. I read Frank's input. While we were in the appropriations meeting, you can multitask. And I have a feeling, you know, that if you look at the mutual evaluation report, as I understand it, it came in October 21, right? Last year. It's slightly over a year, 13 months. And yes, we can carp and complain and we write, but we also have to look, at the other side. They had to bring a bill consulting 5 different departments and entities. And then they brought it to Parliament. The cabinet process, I was there for a while, it's a very onerous process, really. It takes very long. And they have delivered, and they're much more open on this bill, I'm glad to see, than on other bills. So while I think we've been very critical, I think we should also be a bit more understanding. We've been very tough in our previous reports on the earlier, what we call FIC amendment, schedules amendments, regulations amendments, or whatever it's called. So I mean, I read carefully the minister's thing, and I really think that it's a very well-crafted letter, and it's reasonably, I think I'm a bit more empathetic, or less critical than I used to be. The next thing to say is that, you see, if we talk about public participation, these are things that had never occurred to me before, but it's the way the civil society stakeholders challenged us and the way this bill came to be what it has and came when it did, that made me think about things. In fact, so much so that some former MP, who I cannot for that, well, I can understand me, I don't know, was watching us and contacted me that evening about issues around public participation and said, we should reflect on writing a bit about this based on our experiences here. And it's something that maybe when I'm freer, I might pull together. But I think one of the issues is the very special context we've got here, where all of us, including those who are most critical, recognize that whatever our differences, right, from the extreme left to the extreme right, we need this bill, in my view. And I think elements of what I'm saying apply across the political and NGO spectrum. We know that it really is something we need. And so when you're talking about public participation, there's a context. I never thought about this, Frank, before. Something on a bounce of view, actually, also about the legal issues and the policy issues and the normative issues. But I don't know how judges decide on these things, but surely they have to take account of the very special context that, yes, in the National Treasury Simon Waletsane knew from 2017 we're in trouble, but it was only in October 21st that it hit them very hard, that we're in big trouble and we're given just a year to sort things out. So you've got to take that very special context into account and how Parliament processed this bill. Thankfully, the SCOF extended its public hearings for a period limits for another 2 weeks. And then we are open. By the way, I urge you to understand, you are free to attend all the meetings in Khululeko or ensure you know about them. You can attend all of them. And given what has happened, I can put it to the committee. We've done this before, particularly you'll remember on other bills on the SCOF side. Even that one day, remember, on the very day, Tandi Tobias Pokolo picked up that what they were saying, it was a tax bill. Was correct, and then we amended the bill right there and then. So it's harder if you're in NCOP side, any side you can do it. But anyway, there you are. I think that has to be taken into account. That when you're talking about extent of public participation. So, it strikes me that you can have a bill over like maybe 3 months, but the number of hours you spend on it is 20. But you can have a bill for 2 weeks and the number of hours you spend is 45. And here we've said to you, and the offer has to be responded to before we part at 5, A, do you want a further discussion, civil society, on the legal issues? We can discuss offline when's best. I will also try to come, but it doesn't matter. One of us from the study group will be there, but I'll try to be there. If it's tomorrow afternoon, I'm available. We can bring the lawyers together and sort that out. On the issue of public participation, you can put that on the agenda. If you're still unhappy, what is it you want, okay? So we can discuss those 2 issues, or you can respond today. What is it more you want? What would you do beyond what you've done now if we extended, well, we're extending it. Call it public participation throughout. You can attend the meetings. I think we're meeting again on Tuesday in Khuleleko. Give them the program, you can attend. And we'll give you some space to participate if the majority in the committee agree, as I'm sure they will. But the thing that strikes me today, both through my reading and also what I hear now, is that you've had a very big influence on this bill, civil society. Many of the changes that have come from you, including those that forced them to go to Jeremy Gauntlet and take what he said seriously, have in fact been effected. In fact, if you look at the annexures, in tracking, Janine has sent the changes that have been made to the bill based on the senior counsel's opinion, which came about because of the pressure you put. So you've had a very big influence on this bill from what I can see. And like Frank, I feel it's a continuum. It started in August and we've been going on for 5 months now. And by the time we come to a final conclusion, if we vote on it this quarter, it'll be 5 months. Then one other thing we could put in our report, depending on how things pan out between now and the day we're ready to vote for it, is that the bill be reviewed in a year. And that you come in a public hearing system, a public hearing process, and you present your point of view on what has happened in the year in between. And furthermore, all these promises made about strengthening the capacity of the state and the relevant entities and departments, have they been implemented or not? Then, I want to say also that you're quite conciliatory, civil society. I'm a bit surprised because what I've been reading in the media and people that I know in the NGO sector, none of you's here, unfortunately, who alerted me about this. These are people I know through the years I've been around and in various other ways. I play certain roles outside, well, many roles outside my role here in Parliament. And the former, not former, ANC comrades also picking that up, we're asking questions. And one is a former MP, I think declared, you know who she is. She harasses me about our attitude and, you know, why are we not allowing more space and time and so on. And I had to keep reminding her that I'm not the National Assembly chair anymore. I'm on this side and waiting for the bill to come to us. But I just want to say I'm a bit surprised, colleagues, comrades, and civil society friends, at how conciliatory you are. I mean, the media has been giving us, presenting a very horrid picture of Parliament. And now I see, it's like almost, to be quite frank, I misunderstood. It's like a damn squib in the sense that I really thought we're going to be flooded with people. And yes, you're going to say it's not 4 days, but you know, well, actually, it's been, people know it's with us. Now they can still write to us. If they want to make written submissions, they can. And if there's something good, different from what you're saying or orally, we will ask them to speak. It's not the end of the world, but you have to move also. You're meant to be activists, right? Bring everything you want to bring by Monday morning, and then we will shape our program according to that. So let's go to the issues you've raised, right? Treasury, I'm going to reply to the HPO talking about the practical issues. But I also want to tell civil society, you have to take to the streets, you know, metaphorically and literally. You can't expect merely by raising good points here that you're going to get what you want. Power is, you know, your ability to mobilize. And you need to campaign around these things for a variety of ways, not just petitions and YouTube and Instagram and what is it? It's all the social media that we use, tweets and so on. Yeah, it influences people, but you've got to express collective power around these issues. Your main concerns, it seems to me, fall within the portfolio and select committees of social development, the Department of Social Development Ministry, and so on. Now, you see, the one common thing that you're saying, from what I can tell, is basically you're saying we're in a very weak state. Well, to some or other extent, I agree. I think you're right, not only about this, and the point that is said here by the DA, that, you know, they're not happy about whether we can implement this bill. Well, the same would apply, Dennis, to bills in general. I want to remind this committee, and you see all the new people here, Mama Rakhane, Njadu, Dennis, Willie, although you're older, but you're new in this structure, I think. You have to fight for this. You see, in a bill, we have socioeconomic impact assessments that came after 1994, before which you always had, from the old order, I think, financial implications of a bill. Some of us have been arguing, and we don't win this one. You must have an implementation program or a program of action, which is there in the memorandum to the bill. And then the committee can look and see, well, they're saying they're going to do this, and it's not going to happen. So we can say that in the law, we can say in the bill, we can say this must be implemented within 15 months of the promulgation of the bill. But when there's something else that you see they can't even do, you'll say this has to be implemented within, or ask them, don't you want to bring this clause back when you feel you're ready to implement it? So insofar as those of you in civil society are saying you're worried, so are we. The ability of the director of the NPO to register, so are we. You know more about these things that falls outside our portfolio, so are we. Now already, I think we should alert the Esther Mohobe and her team that these things must go into the report. Our concern about the capacity of DSD and the NPO directorate to do this, our concern about the capacity to implement this bill, our commitment to please, you know, put all these points in. I think you're hoping you're taking this down, because I'm not going to repeat them outside of this meeting, please. You can just switch your cell phones on and record it, but really, we must get this report, the elements of a report done. There's some things that are straightforward. It's all across all parties here and civil society. So on capacity, we are worried about the implementation. We'll monitor it, maybe, what shall we say, regularly, or at least twice a year. And we will meet at least a year from now to review progress in this regard, and we will invite civil society. We can send them any reports that we do once we're monitoring in Kololeko. We'll try to do this in consultation with the NA committee if we can. Now, on the issue of what Anton raised from the HPO, will you reply to that, Treasury? I think I know what you're going to say, but I'd like to hear from you. Now, I want to say the following things. One, I'm about to conclude. Can I just say the conflict with the NPO amendment bill? I'm not convinced, civil society. I'm not convinced anymore. I think Janine's covered it. And I think that the issue now is for Treasury. Can you put this in the report that we recommend that Treasury ensures that the present, I think they've eased some of them contradictions between this bill and that bill, be addressed, and they report back to us on that. And we send the report to civil society, and we publish it on our website. It must be open and transparent. So to Treasury, you have to do it. I know you're overworked, understaffed. Well, everybody is in the state, right? So then the issue of registration now. Can Treasury explain a bit more about it? How onerous is this registration really? Secondly, can you simplify it so that smaller NGOs don't have to bear a huge administrative and financial burden? What, on average, would be the financial burden, if you can actually say? On the religious sector, I mean, isn't it true, Treasury, that it's this sector that perhaps most is concerning because of the issues of combating terrorism and the distribution of money to all sorts of different type of organizations that are hell-bent on destroying democratic societies? I think it's a big risk, the religious sector. But at the same time, I don't see anything draconian in what Treasury is doing. But if there is, they must show us. Now, you know, I didn't quite understand Anton's point, and Treasury can maybe understand about, well, FIC will not be a regulatory authority. That's not what it won't regulate. It won't have to register the FIC, the NPOs, but it has to then play an oversight role. I didn't quite understand what you were saying, but you'll explain to us, and also, you know, tell us why you don't agree with him. But look, the FIC is here. They must speak for themselves about the role that's being suggested to them. Then in my concluding remarks on process, one, you are free, if you want, to have preferably tomorrow afternoon, a further discussion on legal issues, if you so want it, and public participation, those two issues. So I'll come, because public participation is something I want to be responding to. Next is, you are free to come on Tuesday and whenever else we meet. I think it's Friday again. We might meet Thursday night, and Wednesday night if we have to, because we have to look at the parliamentary program on plenaries. And then can you respond for now? So what is it that you want? Now, what I suggest is for our reports, those of you who know each other here, most of you seem to do all of, can you prepare like a one-pager, right, with bullet points even, and say, these are the things that you would like to see happen. And we look at it, and where we agree with it, at farthest part will, and if we don't agree with it, we can put in a section that covers. You see, you made submissions. You've offered summaries of those submissions. No, you haven't, the team by Esther, and in fact, in some senses, they've already begun, and Poppy and Nkululeko will do it. But now that you've heard the story this afternoon, over and above that, why don't you, by Monday, 5 p.m., submit to us separately if you want different points, or collectively, that might be better, and saying that following the part 2 of the public hearings today, these are the things that still worry you. And what we could do on Tuesday is start with what's worrying you. And you can be there. So those are the things we can offer you. Right? Now, having said that, I know I went on and on, but you know, it's not as if people are jumping forward to put questions. Are there any more hands up or make comments? No. All right. So firstly, Treasury, can you respond to the issues they've raised and the members have raised? Then we'll come back to civil society. Then we'll have to draw to a close. Okay, over then to National Treasury. And Frank, you can come in whenever you want. If the research staff want to come in, they're free to do so, which includes the secretary. Nkululeko, if you want to say anything, you're welcome. Right, go for it. Treasury, Bukile.
Thank you, Chair. Perhaps I should start off by, I guess, agreeing with your assessment. I do think overall the engagements have been really constructive, and I think that we've kind of met each other, and I think addressed some of a lot of the key concerns that have been articulated, particularly by the NPO sector. I think that is in part a reflection of the excellent facilitation, both at the standing committee, but this committee as well, Chair. I thought I'd start off by simply saying that. To address some of the issues more narrowly, a key theme that's come up both in your comments, Chair, as well as Honourable Riders, is the question of implementation and making sure that the goals of the law are met and our common objectives are achieved. Chair, we welcome the additional oversight and you holding our feet to the fire, making sure that we implement the law effectively. I guess it's part of the overall oversight that you always have over us, and to make sure that we do what we say that we will do. Chair, we have an additional I guess mechanism for holding our feet to the fire. Not only will it be the rigorous, consistent, and excellent oversight that this and the other committee provide over us, but also in the FATF process itself, Chair, it doesn't just rely on passage of the law. It requires a lot of what you and Honourable Ryder were articulating, which is to make sure that outcomes are met and that we just simply don't rely on the law. So I thought I would mention that as well, Chair. Lastly, an important principle issue mentioned by Kasatu and Mr. Parks. We will be, as you noted, providing additional detail on transparency and sharing of information. Suffice to say that we share your commitment to a level of transparency that will allow the public to effectively engage and to have a meaningful understanding of beneficial ownership in South Africa. So we certainly look forward to engaging with you on some of that detail. I know that it's a little bit too soon now, and we can't show you anything, but certainly when we draft those regulations, we look forward to a deep and meaningful engagement with yourselves and other interested parties. Chair, I'm going to pass over to Peter to take us through some of the details around the role of the FIC and what was meant in the mutual evaluation and how that relates to the text of the draft. But just before you do, Chair, just to mention one additional point on capacitation and the capacity for us to implement this. We have been engaging very closely with DSD. We will continue to do so. We have a second bite at the apple to align some details through the MPO Act itself, which hasn't been tabled in Parliament yet, but I understand will be soon. In addition, we are engaging very closely with the officials responsible for budgets to make sure that we align fully there and we can all meet the objectives that are set out in the bill. Peter, can I hand over to you first?
Thank you very much, Kelly. Good afternoon, Mr. Chair and honourable members. I'll touch on the questions relating to the classification of NPOs as reporting institutions under the FIC Act, and also on the suitability for the FIC to assume a role of oversight for NPOs, and I'll also pick up on some of Mr. Van Dalsen's comments in this respect. And I will just briefly touch on the Chair's comment on the religious organizations, and conclude by also picking up on the capacity issue that Bukele raised just now. So on the issue of the classification of non-profit organizations as reporting institutions, in the first place, that would actually not get us to achieve the objective of what FATF has recommended and what we should be achieving with the protection mechanisms that we need to have in place for NPOs. So I think it's important just to remind members again of the context of these amendments to the NPO Act that are proposed in the General Laws Amendment Bill. We work from the perspective and the assumption that NPOs are credible and reliable organizations that perform good work and are an essential component in our society. We do not approach this from the perspective that we assume NPOs are positioning themselves for abuse or to set themselves up as conduits or fronts for raising funds for terrorist organizations, etc. The requirements of a reporting institution under the FIC Act are very narrow. A reporting institution is required to report large cash transactions that involves the institution and its customers. So if a car dealer, for instance, sells a motor vehicle and the customer pays with a large amount of cash, and in our current regulations, that amount is set at 50,000 Rand and more, then the car dealer has an obligation to report that transaction to the FIC. So that would be basically the extent of the obligations that that NPOs would then also fall under if they are to be classified as reporting institutions. And to enable that form of reporting, the institutions have to register with the FIC so that they have access to the FIC's reporting systems, and the profile is created for them on our databases that they will then use as and when they make these reports. Now, for an NPO, firstly, it doesn't have customers to deal with. So it requires a different paradigm to think of when does an NPO get involved in a transaction that would require reporting. Would it be when it receives donations, or would it be when it makes disbursements? Those are not really the sort of things that we want to see in reporting from NPOs in the context of these amendments, especially not specifically relating to cash, because that's not our concern. It's not about who donates or how the donations are made. It's about the NPO being able to avoid being exploited as a conduit for the various purposes where organizations that are intent on funding terrorism want to use the NPO as a front to get into the pockets of unknowing and unwitting donors. So from that perspective, it wouldn't serve the purpose for us, and it would be very difficult to apply the paradigm of a reporting institution to an NPO in the same way as we've discussed in the past, why it would be difficult to apply the paradigm of an accountable institution that has to identify customers, verify their identities, and so on to an NPO. The objective that we have to achieve from the assessment and that the FATF standards has set for us, and that the mutual evaluation report recommends to us, is to have certainty that governance principles will be applied in certain categories of NPOs, that they will be managed and governed according to good practices. Their financial administration will be sound, that they will operate according to sound principles as set forth in their constitution and governing documentation, and that the office bearers will behave ethically. And those are currently already the requirements that the NPO Act requires of an NPO that is registered under that Act. On the issue of supervision and oversight and regulation, the FIC, I think Mr. Van Dalsen's characterization is accurate. The FIC, in the context of the application of the FIC Act, functions as a regulator. In other words, the FIC sets the expectations and the norms through guidance, etc., that it issues in respect of the objectives that should be achieved with the implementation of the FIC Act. Supervisors, such as the Prudential Authority, then supervise compliance with those norms and expectations by carrying out inspections on banks, for example, and even imposing sanctions on banks if they do not comply with those norms and standards. So the oversight and the enforcement go hand in hand, and that is the function of the supervisory bodies such as the Prudential Authority. The FIC does not get involved in that process unless a particular sector of the community is not supervised by an existing supervisor. So for instance, again, when we talk about car dealers, there's a supervisor for car dealers. And in that case, the FIC steps in and performs that function. In this case, there is a supervisor in the form of the DSD Directorate for non-profit organizations that is established under the Non-Profit Organizations Act. So it would, again, not be possible or even appropriate for the FIC to step in and assume supervision of a category of non-profit organizations in the certain situation where there is an existing supervisor. The FIC can set norms and can express expectations, etc., for compliance, but with the FIC Act, not with another piece of legislation that falls within the mandate of another entity of government, in this case, the Non-Profit Organizations Act. The FIC has no authority in our statute to do that, and we would be acting ultra vires if we did. So those are the contentions that we have to bear in mind when we decide what, with the tools that we have available in our toolbox, what is the most appropriate structure that we can use to achieve what the FATF standard expects of us, which is the protection of non-profit organizations, not the victimization or the imposition of additional obligations on non-profit organizations. That brings me to the registration comment, or the question from the chair. The registration process is currently spelled out in the Non-Profit Organizations Act, and it entails supplying an application that specifies certain information that is prescribed in the Non-Profit Organizations Act, supplying a constitution for the institution, identifying the persons, etc. involved. I'm sure the members of civil society, the commentators here, will have a much better articulate way of describing what that process entails. But it's a fairly minimal-like process of supplying that information to the DSD directorate, the Director for Non-Profit Organizations, who must then execute certain functions, again, very strictly according to the prescripts of the Non-Profit Organizations Act. There are very little discretionary powers allowed for the director in that process. There's no administration fee or application fee involved, so there's no financial application for submitting an application and being registered. What is more important actually for us is to understand what is the consequence of registration. And that is what the end objective of the amendments that are proposed here. The consequence of registration is then that registered non-profit organizations must annually meet certain obligations. It must abide by its own constitution. It must apply sound financial management, accounting practices. It must report on those, and it must generate information in the form of narrative and financial reporting in the form of annual reports, etc. And those are the transparency and governance principles that would protect a non-profit organization from being exploited or its name as a non-profit organization being abused for fundraising, for instance, for terrorist purposes. Very lastly, on the point on religious organizations, we have specifically not proposed that the purpose of an organization should determine whether an organization should be registered or not, but more the activity that a non-profit organization would perform. That would form the basis for the decision whether it would be required to register and be subject to the requirements of the Non-Profit Organizations Act and be supervised accordingly. It is true that many instances have occurred where, not only in South Africa, this is an international phenomenon, that a religious purpose is used. It's not necessarily a religious organization, but the organization purports to have a religious purpose and use that as the pretense to raise funds from unwitting donors, and those funds are then used for diverted to terrorist organizations operating on our continent and elsewhere. In those cases, the non-profit organization is clearly, in fact, operating as a front for a terrorist organization. We're not actually really dealing with a bona fide non-profit organization. And that's not what we're after with the amendments that we're dealing with in these amendments. In those cases, we have to have criminal measures, investigative measures, even intelligence measures to deal with the personalities involved in that type of pretense. But it does also happen that bad actors target unwitting non-profit organizations who are truly religious organizations or any other type of organization involved in fundraising and the disbursement of funding. And along the way, getting their hands on the funding of the organization, either by corrupting officials within the organization or entrenching themselves within the organization and then being able to divert funds in that manner. And that's this type of scenario that we are aimed at protecting here. This is part of a complete framework. This is not the only measure in place. But that's what the FATF had commented on in this finding and in this particular recommended action, when they said South Africa does not have the capacity to protect our non-profit organizations from this type of exploitation. When the FATF talks about capacity, they don't only mean the practical capacity, they also mean the legal capacity. At the moment, South Africa does not have the legal capacity. Because it's entirely, we don't have any expectation that the institutions that should be under this protection will be registered and will be benefiting from the protection of those measures that are provided for in the Non-Profit Organizations Act. So this is one step in that direction, to establish the legal basis for the practice that needs to be implemented in order to afford that, to build the capacity and afford that type of protection to the non-profit community in our environment. And that, I will conclude, Mr. Chair, brings me to the point on capacity again. It's absolutely essential that South Africa builds the capacity based on a sound legal basis. This process of bringing in the amendments to the legislation is only one step in a much longer and much broader process to improve that capacity that the FATF has identified as being lacking. And that certainly means building up the ability for effective supervision, effective implementation of the Non-Profit Organizations Act. And in fact, using a very good legal framework that we have at our disposal with this adjustment that these amendments are seeking to make. Thank you, Mr. Chair. I'll end there.
Okay, anybody else? Civil society now. From Treasury side, are you done? Fukile, are you done?
Yes, Chair. We're super mindful of the award we won earlier.
Don't let him intimidate you. Okay, so over to civil society in the order that you first spoke.
Thank you. You hearing me? Yes.
Yeah.
So I think I'm probably guilty as charged for not being combative enough. That's just my nature. But I think also on the whole, and there were certainly discussions in the civil society forums about rioting and demonstrations, and there were many actors in that arena who wanted to do that. And
well, not rioting, demonstrations, yes. No one's encouraging rioting. Least of all, a legislator. Ooh, okay.
No, okay, yes. So, but in fact, those kinds of measures were actually decided against in favor of a conciliatory and engaged response. And it's just because, as you said right at the beginning, Chair, in fact, it's because we're all on the same page here. We all wanted this thing to go through. And as was demonstrated in detail in our previous meeting, it is the nonprofit sector that will be first and hardest hit by any grey listing. So that's where you've got us, is that I think it's about 17 billion or something per annum of foreign funding that's at risk in terms of the work that's being done. So yeah, just to answer that that note, I mean, on our main point, we know that we've been heard, which is that the very wide range of nonprofits that there are means that nonprofit organization registration, lightweight as it is not useful or appropriate to all, and for some very small organizations would indeed be unduly burdensome. Most of that burden, though, as everybody who deals with this knows, actually comes from the ineffective administration from being within DSD. And our objection is also has also been based upon our knowledge that NPO registration does not lead to any actual meaningful oversight of the governance or the work of the organization. It's a tick box surface compliance only. It's very easy to fake. And in fact, as we've already said, 10 years out of date in terms. So there's the scale of the work that has to be done in order for there to be, for the protection, which Peter Smith has spoken about, to be given to the nonprofits, which is a lovely way of phrasing it. We're a long way from there. Hey, Anne, I see your hand. Sorry, handing over to my colleague.
Yes, I think you've said it all. Well done.
Okay. All right. So thank you. Those are my points. And I think that's it. And look, Peter, thanks for that response on the details of the FIC. I think too that there's been a lack of clarity from the beginning of the consultation, certainly in everybody's head, about what was actually trying to be achieved. What are we trying to get at? And in some of the consultations, people have said, we don't want to have oversight and we don't want to be nannying the nonprofits. We just want to have this regulatory thing in place so that we can know who are the bad actors. And so we've got an initial offense because they haven't registered. So there's been that said, and then on the other side, people have switched tack and said, no, we want to build a stronger regulatory oversight governance framework for nonprofits. So there has been that confusion, I think, in terms of what is trying to be achieved in terms of this very ambitious bill. So, okay, that's me.
Okay, who's next? Comrade Jadu, just to let you know, to lift my spirits. Our comrades in Samu turned up today to collect the garbage outside. I just heard the big truck rolling down the street. So at least that's something to lift my spirits on a Friday. It's not always that you get your bins collected. Right. Who's next?
Chair, it's the Helen Sussman Foundation. I think on two issues. One, on the question of public participation, I think given the circumstances and your comments when you were addressing this issue just now, this is not something we want to take any further. I think this whole process, it's something of it's an out of the ordinary process. It's an out of the ordinary situation. So that's not something that we are going to push any further. The second issue is what Peter Smith, the explanation that Peter Smith gave, and the supervisory function. I think effectively what you have now is that you are confronted with a choice. The first, should we say option A, is to create a brand new department in the Department of Social Development to deal with an aspect in which they have no experience and no expertise. Or the second option is, again, you adjust the legal framework of the FIC to use the reporting institution mechanism to make an appropriate adjustment, legal adjustment there. And in this context, let me just mention there are only two clients, I use the word clients, in the reporting institutions in the FIC, as I understand it. And those are car dealers and Krugerrand dealers. And I think the issue here is it's not for the FIC to get involved in supervising NPOs in general. It's only in supervising NPOs who make substantial foreign payments, as I understand it. And I would imagine that this is something that the FIC has the necessary experience and the necessary expertise to do if its act or regulations in terms of which it works are adjusted. So I think that is the clear choice that you are confronted with, Chair. Thank you.
Next, Cause for Justice, I think it is.
Yes, thank you, Chairperson. At this stage, we don't have any further comments or inputs, except to thank the committee and National Treasury for the process today. And yes, and also, as the previous speaker said, we are not going to take the issue of public participation further. Thank you.
Kusatu?
Yeah, no, thanks, Chair. And just apologies for my unusual background. No, I think, Chair, from our side, we're always ungovernable, Chairperson. We're beyond redemption.
You're on the streets. I didn't mean in your car.
with the masses. No, Chair, I think so. From our side, I think this has been a positive process because we were very concerned at the beginning, Chair, as Kusatu, around the whole beneficial ownership issue. We really felt there was too much secrecy there. We think we need to really move to a society of maximum transparency and accountability, oversight, right, to minimize some of our many sins from corruption, etc. So I think we are very pleased with that Treasury has, come with substantive amendments to address those concerns. I think, with a real gun to its head, the Standing Committee of Finance and the NA, we think did quite well, and to give space to everybody, even to our colleagues from the NGOs who have legitimate and valid fears and concerns. So I think for us, Chair, it's about processing the bill, getting it passed into law, so we avoid the grey listing, which we're very worried about would be devastating to the economy. And then, of course, Chair, we will, as COSATU, continue to engage with Treasury and NEDLAC on the regulations, because we are still quite worried about making sure the public access to information in the beneficial and ownership and the trust issues, trust deeds, etc., are addressed in the regulations, because you don't want to have a bill which has progressive, lofty ideals in the bill, but on the practical implementation we're then found seriously wanting. So I think it's going to be a bit of a journey, but I think we've made some good steps in the way forward. So we're quite optimistic and quite pleased. We have made some solid progress so far, Chair. I think to appreciate the space MPs have given us as well. So thanks very much, Chairperson.
Okay, now members, who wants to come in and respond to the issues that were raised by both sides? Okay, I don't see any hands up, not even Dennis. Look, firstly, when I said you must take to the streets, it's not something that is a popular statement. It relates to a particular view of some in the majority party, and certainly others outside, that we need a strong civil society. In theory, that's what we say as a majority party, that binds all of us here who are ANC members. But in practice, and I've raised this in many forums, publicly and within our structures, we seem to be afraid of NGOs. Yet we need you like never before, as I said when we started. So I want to start here in my concluding remarks by saying, we need you. You must continue to do your work. You must continue to hound us where we do wrong things, but then support us when we do right things in the interest of the poor and disadvantaged. But I really do mean that you have to flex your muscle in a variety of ways, and you have to help us rescue this democracy. You can't rely on the state alone and the majority party or any political party, really. It's civil society, it's individuals out there that will ultimately have to bear the burden of rescuing and consolidating and advancing this democracy, development and delivery. After all, yes, political parties, our liberation movement in particular, the ANC, played a key role. But it's the masses ultimately that overthrew apartheid. And it is the masses that must take to securing this democracy, which is what they actually did most for, and we led them on. When I mean we, I mean the political party I come from. So I mean that, we have to have a cooperative and competitive and contested relationship between the state and civil society, between government and civil society, between parliament and civil society. Secondly, on your side, you need, when you make representations, this is something you want to think about, to be more demographically representative of the population of our country. It's something I raised originally. But every person, whatever their background, carries the same value in bringing issues here. We all have the same rights as citizens, whatever our background. Now, when I made that silly Billy remark, it's not so silly Billy, that people came here. They're my people, they're my comrades, my friends who run the municipality, to collect the garbage is because they meant to be here in the morning and they got here about 10 minutes ago. So to communicate that we MPs don't sit in a bubble, right? In a way we do, but in a way we don't. When Eskom's lights go off, they also go off here in Ward 36, okay? And when the water outages occur from the municipality, I also have to bear with it. The bins are not collected every Friday, and I have to deal with it like the poorest person in my area. So what I'm saying is, we're acutely, excruciatingly aware of the weakness of the state. And you are spot on in everything you say. I don't know enough about DSD and the non-profit directive, but I know enough about the state, as do those of us who are more experienced MPs here, or those of us citizens in this country. We experience it daily with the municipality. So look, on that score, you've been very good, and you don't need to apologize, not that you have, but I just want to tell you, most of us here, certainly I speak for myself, and I think the majority in my party as well, will agree with you. Then, you know, from what you're saying, you don't want to meet on the two issues that I think need to be now processed outside of a full committee on Saturday afternoon. Have I understood you correctly? If I haven't, just put in the chat group, because I'm suggesting meet from 2 to 3 hours if you want, on unhappiness if you want, about the constitutional issues and public participation. Then the next issue to say is, look, Treasury. But you know what you should do, civil society? Maybe one of you could do it, or all of you could do it collectively, or those of you want to do it, do it. Can you write to us, right? By, let's say, noon on Monday, and tell us what it is, you know, as I said earlier, after today that you want raised further. What are the practical issues? Even if you put it in a nutshell, you know, and say, you've been saying it here, but we need it in a report, because a report goes onto the website. It's a record, right? So in 14, 15 months from now, we're not going to be here, but the committee that comes in has a report. In our exit report, we will say that we committed ourselves to at least twice a year monitoring progress in this regard. Okay. Now, what are other things you think we should do to ensure that we strengthen the capacity of the state to deal with this bill, and the capacity of the state to deal with the outstanding issues you have that have to be addressed through DSD and the committees on the both houses in regard to that, okay? So what do you think should be done? That we'd be very grateful for. Remember, we have various options in a report. We can just state that this is your view after the hearings this afternoon. This is the further points you want to add. Or we can incorporate what you're saying into our recommendations and say, well, we recommend that the above proposals by civil society organizations that appeared in the public hearing are implemented over time. Now, you are also, let me remind you, free to attend. All meetings are open, and since it's virtual or hybrid or virtual, the committee meetings, you know, you're welcome. And if you do make a presentation to us, there's another option. You know, by Monday at noon, we can look at it and you can convert in Kuleko, and we can respond to that the following morning. And you can participate before we start evolving our policy positions. And colleagues, we will use Janine's document, but it'll be managed by me now as the chair, and say, okay, on this issue, what are we saying, that issue, and so on. Then finally, from my side, but before I conclude, I take it that you will put something in the chat group or reply now. We're saying to you, yeah, okay, Nicole from NGO Law says by 5 p.m. Okay, fine, let's do it. 5 p.m. on Monday, it's fine. Then you can tell us if you want us to respond in the committee process, and we will do that on Tuesday morning. 5 o'clock is fine. Okay, so that matter is settled. So I take it the meeting for tomorrow is off. And if you still want one sometime during the week, we can meet outside of the committee hours, because please remind NGOs here, it's the same committee that deals with appropriations and finances on the NCOP side. Secondly, we've got bills on the appropriation side, including the appropriations bill, for which we had public hearings this morning. And then we have tax bills on the Select Committee on Finance side. And we've got less than 2 weeks to process all of that. So then the final thing to say to Treasury, I think we should put this in our report. Can members think about this? But a tentative draft would be, the committee reiterates its view, because we said it somewhere before, check, or believes that bills that are brought to Parliament, just as they include, financial implication side in the memorandum and need a socioeconomic assessment, but we've got representations on that matter about why it didn't happen, and Presidency gave the exemption it did. You got all the documents. If you want to raise that, committee members, you can do it on Tuesday. It should also include a program of action on the practical implementability or whatever the word is, or feasibility of implementing a bill. But we are alert, we feel very strongly, Treasury, that more than most bills, this one has to be implemented. Because you see, the FATF is not interested, nor should we ever be, in the words, the dry words on a paper or these days on a screen, okay? If we don't implement it, we're going to be in a worse situation. I don't understand what FATF is really about. I don't understand how they function. It's an executive or departmental structure. Parliaments, I don't think parliaments go there. All I'm telling you, which is something you know, that if we don't implement it, it becomes like a farce. And FATF and multilateral institutions observing this, and the private sector globally, it's going to say, you see these people, they just went through the motions, they can't even implement the bills they pass, and this is a further need for us to isolate them, even if not through FATF, through their own private sector decisions. So please, 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 can you please implement this bill, and can we as Parliament do our jobs, which is to hold you to oversight. And so, members, if you've got ideas on how we can hold him to oversight, bearing in mind our constraints, that we, 2 committees in one, and next year is going to be a difficult year because, as normally happens, the executive dumps us with bills in the last year of our sitting. And then you know what's going to happen. By the second half of next year, Parliament will begin to fade because the elections are looming, as happens all over the world. What do you think? People are going to sit around debating bills. They'll just defer them to the next term of Parliament. Right. So having said that, is there anybody else who wants to add anything from the committee side or civil society? You want anything to say? Because we're drawing to a close now, unless something dramatically new emerges. I don't see any hands up. On the committee side, anybody wants to say anything? Nope. All right, we're done then. Thank you all. And we shall meet you on Tuesday.
Thank you, Chair. We can't wait.
Thanks, colleagues.